Hello, everyone. My name is Tyler Patko. I'm a partner in the Labor and Employment Department of Husch Blackwell. We're very happy and excited that you're joining us today. Welcome to our first California Labor and Employment Annual Update, the first of many. And we're going to talk about three general topics today. And I'm fortunate to have very talented people around me, including our all-star cast, who I'll introduce in a moment. Before I start with introductions, I want to cover a few housekeeping issues. One is, if you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today. If a more expansive answer is required for one of your purely hypothetical questions, we will respond by email to make sure we cover those questions. A PDF of the presentation is available in the program materials folder. The program has been approved for legal education credit. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. That makes me nervous. Toward the end of the program, be sure to complete our short survey. We really appreciate your feedback. We want to make this a engaging, interactive program today and in future programs as well. Along that same note, we have a limited time here today, 2 hours. So if you have really pressing, complicated or cutting-edge issues, feel free to email us with suggestions for future webinars. We already have a few ideas in preparing for today. So that's it for the housekeeping items. Let's get started with our program. The three sections we're going to cover today, my colleagues Olga Savage and Allison Scott are going to cover the meat and potatoes, the 2022 new case law overview. After Olga and Allison are done, then Michael Mata and I are going to cover everybody's favorite topic, wage and hour, class actions, PAGA, not going away anytime soon. So first up, I want to introduce Olga Savage. She and I have worked together for 16 years, but who's counting, right? Olga went to some law school called Stanford. I'm not sure exactly about that credibility of that school, but she is a very experienced employment lawyer, labor lawyer, and joining her is a 2021 Southern California Rising Star. I think she's already a star, Allison Scott. We call Allison, don't let her looks deceive you. We refer to her as the baby-faced assassin. She kills them with kindness and disarms them. So don't let that pleasant, calm demeanor fool you, especially if you're on the other side of her in a deposition. One last disclaimer, lawyers love disclaimers. My disclaimer that I've used in prior years is we don't make the laws, we just tell you how bad they are. We are not, don't kill the messenger, don't shoot the messenger. We're going to tell you when there's a little silver lining, but it's not all good for California employers, again, in 2022. So with that, I'm going to turn it over to Olga and Allison.
Thank you so much, Tyler. Hello, everyone. Thank you again for joining us. We are going to jump right in, not a moment to lose. And the reason for that is that Governor Newsom signed a whole lot of employment legislation towards the end of this legislative session on September 29th and 30th of this year. And prior to that as well, amazingly, not all of it is related to COVID, but all of it has the recurring theme of giving employees additional rights, imposing additional obligations on employers. And we'd like to cover that for you as comprehensively as we possibly can today, before also moving on and talking about some recent developments in the courts that also have a huge impact on anyone who has any employees in California. So we'll dive right in on the legislation first and then move on to court decisions. First category of legislation that we want to talk to you about today is various new laws that provide additional protected time off rights for California employees. So we've had this overarching theme going on for the last couple of years where we've got the California Family Rights Act, CFRA, CFRA, I think we can create a poll on how to pronounce that correctly, the California equivalent of the FMLA, and we've seen this gradual increase of rights under that law. So we had in 2021, it was expanded to any employer over 5 employees as opposed to the 50 employee requirement. Then we had additional categories of relatives added to the list under CFRA as to which relatives are qualified for an employee to take CFRA leave to care for them. It expanded in 2021. It expanded again in 2022. And now, effective 2023, we have another expansion of the list and categories of persons for whose care an employee can take CFRA leave. So now, in addition to the list that we already have, parents, spouses, domestic partners, children, in-laws, grandparents, an employee can now designate a designated person that falls outside of those categories and take CFRA leave in order to care for that designated person if that designated person has a serious medical condition. And that new right went into effect not only for CFRA, but also for the California Paid Sick Leave Ordinance. So under CFRA, an employee can now take CFRA leave to care for a designated person who is either an individual related by blood or whose association with the employee is the equivalent of a family relationship. I have absolutely no idea what that means, to be perfectly candid. We're going to find out what that latter category means when an employer actually decides to test it and to deny leave to someone who's seeking to take leave for someone who's not a blood relation. So right now, we're still somewhat limited on guidance on what that means. So then under CFRA, an employee can designate a person outside of the usual categories for whom to take CFRA leave. Under the paid sick leave law, it's similar but even more permissive. Under this new expansion of the California paid sick leave law, an employee can designate any person for whom to take paid sick leave. So there isn't even that requirement that it be a family member or a blood relation. It could be literally anyone, a neighbor, a friend, etc. Now, there are some limitations on what an employee can do in terms of designating a person under CFRA. The employer can limit the employee to designating only one person, one additional person per a 12-month period. So for example, an employer can say, no, you can't designate your aunt at the beginning of the year and then designate a cousin 6 months later. You can limit it just to one, but the employee, upon requesting leave, can create this designated person category. And this creates a really interesting situation for those employees who are eligible both for CFRA leave and FMLA leave. So those employees who fall within that 50 employee plus category that are entitled to both. Because usually CFRA and FMLA run concurrently, right? As an employee is using up CFRA leave, they're usually also using up their FMLA leave entitlement. But in this new situation, in theory, an employee could take CFRA leave to care for an aunt, use up those 12 weeks of leave, and still be entitled to FMLA leave to care, let's say, for an ill parent later in the year, because that leave to care for the sick aunt wasn't FMLA leave. So we've got this very interesting additional new leave entitlement, and employers need to be aware of that. And we would definitely recommend that you update your leave policies to reflect this new right that employees have under CFRA and under the California Paid Sick Leave law. So that's that new leave entitlement. We also now have a law that entitles the employees to bereavement leave. And that's a very new notion, because up till now, bereavement leave has been purely a function of company policy or a contract. If a handbook or if a policy or a contract provides for bereavement leave, they get it. If not, there's no legal entitlement. Now, under this new law that goes into effect on January 1 of 2023, California employers with 5 or more employees must provide eligible employees with up to 5 days of unpaid bereavement leave per death of a family member. Now, the leave does need to be taken within 3 months of the death of the family member. It does not have to be taken consecutively. The definition of a family member is essentially the same of what it was under CFRA before this new designated person right went into effect. The employee needs to be employed with the employer for at least 30 days to be eligible for this leave. The other thing that's really important to remember is that this leave does function in connection with whatever bereavement leave policy the employer already has. So if the employer does already have a policy that provides for 3 days of paid bereavement leave, under this law, the employee is entitled to those 5 days. Those first 3 days do need to be paid. Those last 2 days can be unpaid. However, the employee may, if they so desire, use their accrued PTO, accrued paid sick leave, etc., to have those last couple of days be paid as well. Documentation requests are okay, and obviously there's no retaliation for exercising this right to take bereavement leave under the new law. That's the bereavement leave provision. One more that I will mention very briefly before I turn this over to Allison to talk about a different category of new laws is emergency condition leave. And I know we think of emergency condition, we automatically assume COVID. No, this actually doesn't really have anything to do with COVID. This new law was enacted out of a concern that the employees feel compelled to come into work in a situation where there's a national emergency, a health emergency, not a health emergency, a weather emergency, an active shooter situation. So this is basically a law that says that an employer cannot retaliate against an employee for refusing to come to work or for calling out of work if there is an emergency condition, such as a disaster condition and a condition where extreme peril would result to the employee due to coming into the workplace, active shooter situation, a natural disaster that impacts the employee's home or their child's school. So under this leave, it doesn't include health pandemics, but under this leave, employees have the right to stay home under this situation. And employers should update their safety protocols to ensure that this right is articulated. Turning over to Allison.
Thank you, Olga. So in addition to adding additional time off for employees, California legislature has also added additional protected categories under the FEHA. So we have off-duty use of cannabis and reproductive health. So effective January 1st of 2024, you're going to see that off-duty cannabis use away from the workplace is going to be considered protected. So what this really means for employers is revamping your drug screening policies and making sure that you're only detecting for impairment on the job. That was part of the reason why the legislator enacted this addition to the FEHA, because there is a concern that drug screening as is only detecting cannabis use that occurred in the past, not necessarily detecting cannabis use currently going on or any impairment in the workplace. So it is going to require pre-employment drug screenings being revamped. Also, any employer-required drug screenings are also going to have to be revamped to make sure you're not screening for past cannabis use. They're interesting enough, though, employers may still maintain a drug and alcohol-free workplace. That was one of the things that the bill's author made clear, that there is a consensus that we don't want employees showing up to work impaired or using cannabis or marijuana in the workplace or possessing in the workplace. So under this new law, there's still a right to do federal drug testing as required by federal regulations. It's not preempting any state requirements regarding drug testing. Again, if you're working in building and construction trades, there's also an exemption for those individuals there. We don't have a lot of guidance yet, so hopefully in this next year we'll get more guidance about what kind of drug screenings are going to be permissible and how it's going to shake out, because I do anticipate that's going to be highly debated in the future, especially if you have employees testing positive for drug use. Again, if you're using a vendor, it's important to work with your vendor to make sure you're going to be compliant come January 1st of 2024. Because even though your vendor might say that there's a positive drug screen, if you take any adverse action against your employees and they weren't impaired on the job, it's going to come back onto you as an employer. So we do recommend employers reviewing their drug screening practices, updating their drug screening policies and their drug use policies to make clear that off-duty use of cannabis away from the workplace is not going to be punished or taken adverse action against. You also should revise your California policy on prohibiting discrimination, harassment, and retaliation. Hopefully everyone remembers that in California there's specific regulations for these discrimination, harassment, and retaliation policies, including listing all protected categories. So your harassment, discrimination, retaliation policy should address that. And then also you should work on training employees. Managers and supervisors who believe employees might be impaired in the workplace should have that training to understand what signs to look for impairment and what kind of action we can take against employees if they are impaired in the workplace. So it's really important to take that next step. After that, California has also added to the FEHA a protected category called reproductive health decision making. And so that is actually effective January 1st of 2023. This amendment is part of the Contraceptive Equity Act of 2022. Notably, that act also includes lots of other provisions regarding reproductive health, and especially with respect to health insurance plans. So, but for our purposes today, in the employment context, it's just important to note that reproductive health is going to be a separate category under the FEHA. So again, you should be revising your policy prohibiting discrimination, harassment, retaliation to include that category so you stay compliant with the FEHA regulations. It's also important to know that even though they have created a separate category under the FEHA, reproductive health decision-making can still also be considered part of sex. And also, at the same time, you, as an employer, cannot be inquiring about an employee's or an applicant's reproductive health decision-making. The new amendment has made that clear, that employers who condition employment, continued employment, or benefits of employment based on inquiries about reproductive health decision-making are going to be in a violation of the FEHA. So, and now I'm passing it back to Olga for our privacy protections for California employees.
Thank you, Allison. So we are now 4 years later since the enactment of the California Consumer Privacy Act back in 2018, still trying to figure out exactly how to comply with it. As you may recall, California Consumer Privacy Act, CCPA, first United States-based comprehensive piece of data privacy legislation. We're trying to be like Europe that has had this in effect prior to us. It was passed so quickly and rushed through the legislative process so fast that it came out as a very unclear law with a lot of holes to be filled in. So for the past 4 years, that's what we've been trying to do, right? Is basically to fill it in and figure out how the heck we're supposed to comply with it. And that includes this new law that went into effect, the California Privacy Rights Act of 2020, that basically serves as an amendment to the law and provides further guidance. So this is for companies who in any way collect personal information. It imposes certain obligations on them in terms of providing disclosures as to how that information will be used, data security, certain rights to opt out of having the information disclosed by the consumers, et cetera. So up until now, there has been an exemption to this requirement for data that was collected purely for the purpose of employment. So data collected by employers from employees and applicants. Now that exemption is going away. It was intended to expire at on January 1, 2023. The exemption was not furthered or renewed, although several bills were introduced to renew it. So now it's gone. So now employers have to comply with this data privacy requirements when it comes to the personal information that they collect from employees and from applicants. And there is now a long set of rules, very specialized requirements that employers have to deal with. So that things like providing employees with disclosures, we're collecting your personal information for the following purposes. There's data storage and data security requirements that employers have to comply with in terms of how to store that data. Employees have certain access rights. They can review the data that's being stored. They can ask that certain data be either corrected or removed, subject to legal requirements, right? If an employee can't ask an employer to delete a piece of information that an employer is required to maintain by law. But now employers have to deal with this very, very complicated framework. And my hope is that because we've had this warning coming down the pipeline for quite a while now, those employers who are covered by the CCPA, it doesn't cover all employers, and you want to make sure you determine whether you're actually covered or not, have already been working on creating a data privacy policy, creating that disclosure, evaluating its information storage systems to make sure that they're compliant, developing the appropriate policies and procedures, connecting and working with vendors who may assist employers in collecting personal information, whether it be personnel information or health information or anything like that. So now is the time to put all of those measures into place. Very, very important to make sure that you're compliant, because the time to extend that exemption has run out and employers now have to comply. So that's kind of the biggest update on privacy. There's a slightly smaller and more specialized new piece of privacy legislation that caught me off guard, because apparently we now have this thing called digital license plates. I don't know if anybody has heard of this. I certainly hadn't until I saw this law. Apparently we now have digital license plates that contain a GPS tracker, that contain all kinds of various metrics that can be used to monitor vehicles, to assist if a vehicle is stolen, to monitor certain vehicle and driving conditions. It's pretty crazy. So now we've got this law in effect. AB 984 was signed into law, which authorizes the use of these digital license plates, which is great, except that if you're an employer and you're thinking about putting digital license plates on your company vehicles, you've got all these obligations that you have to satisfy, which includes you can't actually do that unless tracking and monitoring your employees' movement is strictly necessary for their job duties. And even if you clear that hurdle, you determine, okay, this is the type of job where we have to monitor our employees' movement. It's part of the requirement. It's a driving-based job. We have to know where they are. We have to know where they're going. You still have to provide with employees with very lengthy and detailed disclosures that describes the monitoring, puts them on notice of the monitoring, explaining how the monitoring works, when you're going to be monitoring, how you're going to be monitoring. You have to give the employees the option to make sure that they can turn off the monitoring function when they're off of work hours, if for some reason they still have that vehicle, while not on work hours. So all of these, so this digital license plate is great, but it comes with all of these additional obligations for employers. And if you violate those obligations, then there's a number of statutory penalties that can range up to $1,000 per employee or per violation that come into place. So great new technology comes with the usual burdens and difficulties if an employer decides they want to use it.
I'm still catching up. That's great. I was going back to the California privacy law. What's the employee threshold for employers to be covered?
You're talking about the CCPA.
CCPA.
So it's not an employee threshold. There's a couple of different requirements to be eligible. So first of all, you have to be a for-profit business that operates in California. And then if you satisfy those requirements, there's also 3 different ways in which you might potentially be covered. So for example, if you have an annual gross revenue of more than 25 million, you're covered. And that's really the only one that applies, strictly speaking, to employers, because the other qualifying criteria are like if you collect the personal data of over 50,000 people, if you sell personal data. So really, I think the biggest threshold one is for the 25 million gross revenue. And if you hit that, and if you're a for-profit employer doing business in California, you are covered by the CCPA. All right, Allison, tell us about other laws.
Okay, sounds great. So, here are some other important labor and employment changes, but please note that there are also several other laws that we just couldn't include with our presentation today. And so here are some important ones, and they're kind of industry specific. So one of them is the removal of the certain requirements for a declaration to be signed for individuals in home health care services. So it's important when doing any home health care background checks that you follow up on that new provision. The next one is AB 1788, and that concerns liability for hotel employers. So previously, California has required hotel employers to provide training regarding sex trafficking. It was about 20 minutes long. Now California has taken further steps and has imposed some civil liability onto hotel employers who have supervisory employees who knew or acted in reckless disregard of sex trafficking occurring in the hotel and not reporting it to the police, the national hotline, or other applicable agencies. Also, the law imposes liability if there's employees who are receiving any financial benefit or knew about some potential financial benefit for sex trafficking occurring at the hotel. It does give the city and county attorneys authority to institute actions, and there are civil penalty provisions for first violations, second violations, third and fourth violations. So it's interesting. So if you're a hotel employer, you definitely want to follow up and see what those new requirements are for you and make sure that you are complying with the training requirements and implementing policies for your employees to know that sex trafficking needs to be reported appropriately. AB 2282 is an actual amendment to the penal code. So it's not in the employment context, but it does expand the definition of hate crimes in places of employment, also in other places too. But it is important to have that in mind, because as employers, we have an obligation to maintain a workplace free of discrimination or harassment based upon protected categories. And so the hate crime statute, even though it's not going to necessarily apply in the employment context for your employees, if somebody's displaying imagery that could be considered a hate crime, such as a noose in the workplace, then you need to take action, and it could be a potential criminal liability for that employee. The next one is AB 2960. So this is something that kind of applies in more limited context. So in California, the California Civil Rights Department, formerly known as Department of Fair Employment and Housing, has the opportunity to investigate complaints or even file a civil complaint on behalf of a complaining employee or issue a right to sue. So typically, though, most of the time in most of the cases here in California, employees ask for immediate right to sue instead of the DFVH or now the CRD investigating. But in the instances when the CRD is going to investigate, there is tolling on like the deadline to issue a right to sue or initiate a civil action when they are investigating or when they're submitting the action to or the complaint to mandatory or voluntary mediation or dispute resolution process. So that is something important to keep in mind if you do have any CRD or DFH charges pending that are being investigated. Now those deadlines are going to be told pending those investigations. So in addition to California's legislator making lots of new employment laws each year for everybody to comply with, California has lots of localities that are very active in creating also new obligations for employers each year. So it's always really important to remember to check any local changes to labor and employment laws. San Francisco and LA tend to be the most active, but other, cities like San Diego are also very active in creating new requirements. So here's a couple example. San Francisco passed a public health emergency leave this past year. And so if you have employees working in San Francisco, it's important to make sure that you are complying with that new San Francisco local ordinance and providing the leave in compliance with the ordinance. Same thing, West Hollywood has enacted this past year paid time off, and it substantially provides substantially broader rights to employees than like California paid sick leave or even like LA city sick leave. And it also provides some personal time off. It's not just sick leave purposes. So if you do have employees in West Hollywood, again, important to take a look. And like just this past week, the Los Angeles City Council has passed an ordinance for fair work week scheduling, and it will apply to like larger employers. But if you are an employer in LA, you want to check it out, make sure it doesn't apply to you. If it does, making sure that you know how to comply with those new requirements. Those are just a few examples, but it's always a good reminder to check local ordinances in each city and county that you're operating in California, because those rules will apply and they sometimes are broader. So passing it back to Olga.
Yes, and I am going to move off of legislation now, and we're going to talk about court decisions. Obviously, just as impactful on employer obligations in California, court decisions on certain critical issues came down the pipeline this year that we all need to be aware of, starting with arbitration. The usual suspect, we're always going to be talking about arbitration and the new cases. So we hear a lot about the fact that, at least from the federal perspective, from the United States perspective, arbitration, favored remedy, more efficient, cheaper, better than the courts. Agree with that what you will. The whole idea is that there's a policy favoring arbitration, or so we're told, except we're in California. California has seemed to not be quite as keen on arbitration as many other locations, and there's been a lot of attempts, both from the legislation and the court, to whittle down arbitration to the extent possible. So recall, we had that law that went into effect a few years ago, AB 51, that we're still fighting about, that said that employers can't actually have mandatory arbitration arbitration agreements as a condition of employment. Tyler and Mike are going to talk later on in their presentation about things that California courts are doing to try to whittle down this very favorable federal decision that we recently got about potentially being able to force PAGA claims into arbitration. So we do have a bit of a trend here. This is part of it. This fourth piece that I'm going to talk about is part of it. So just to give you some context, a couple of years ago, the California legislature became concerned about situations where an employer or any other party who was the one who drafted the arbitration agreement was deliberately failing to pay arbitration fees on time in order to, basically justice delayed is the best form of justice, I suppose, is the theory. So the legislature became concerned about that, and they passed a law which basically says that, okay, arbitration is filed. The arbitration agency issues an invoice. The first filing fee is due upon receipt of the invoice. If the employer or the party who's drafted the arbitration agreement fails to pay the fee within 30 days of the due date, then the employer is in material breach of the arbitration agreement and waives its right to arbitration completely. And that applies both to the initial filing fee and any subsequent fees. So let's say a fee becomes due, an additional fee becomes due 6 months into the arbitration. If it's not paid within 30 days of the due date, the employer waives their right to arbitration. The employee gets to go into court and take the case out of arbitration and back into court. So really, harsh remedy for late payment of a fee. So there were some arguments made when this law came down that, look, there's a couple of reasons why this law just definitely is not proper. The first one being is that it is preempted by the Federal Arbitration Act. The Federal Arbitration Act preempts, does away with, supersedes any laws that undermine and frustrate the FAA's policy for favoring arbitration. So there are several decisions, including this court case that happened in 2022, this year, this Gallo case, in which the employer argued this law should not exist because it frustrates the purpose of the FAA. It undermines arbitration. It is disproportionately unfavorable towards arbitration. The court said, nope. That's absolutely not true. This law does not undermine or disfavor arbitration. It actually furthers the FAA's objective because it ensures a quick, inexpensive, and conclusive resolution of a dispute. So no, this law is not preempted. It gets to stay. It remains in effect. All right. So what about if there is an accidental or inadvertent failure to pay on time? There's no strategic delay. The employer something gets miscalendared or not calendared correctly, or there's a delay in something going, wire transfer going through, and the fee is paid a couple of days late. No harm, no foul, no prejudice. That shouldn't be a material breach, right? So, and that's the argument that was made in this Espinoza case this year, where the employer inadvertently failed to make timely payment because of a clerical error. Fully an accident. Payment was made shortly thereafter. Absolutely no prejudice to the employee. So the employer makes the argument that, well, this was purely an accident, no harm, no foul. I'm in substantial compliance with the obligation to make timely payment and with the arbitration agreement. So no, we haven't waived our arbitration right. The court said no. Basically, what the court said is these laws contain no exceptions for substantial compliance, unintentional late payment, or absence of prejudice. So I don't care if it was an accident. I don't care if you made the payment 3 days later when you realized the mistake. You're out of arbitration. So it's a really draconian approach, which means that even the most minor and inadvertent delay in payment could mean that the employer is out of arbitration. And all of that effort that was made into having, an arbitration program and a good agreement, it becomes useless, which really comes down to the fact that employers need to be really, really careful about monitoring all correspondence for payment deadlines. And remember, those payment deadlines don't always come in the form of a classic invoice. They could be on page 4 of a 7-page letter. So you have to be from the arbitration agencies. So you have to be very, very careful, because this is definitely indicative of a trend in California to not necessarily favor arbitration. And the hardline position that the state has taken indicates that they are going to be enforcing this very, very strictly. So be very careful about that, or you inadvertently waive your right to arbitration that you worked so hard to attain. Other arbitration decisions, Allison?
Thanks. And just to kind of add on to that too, make sure that you're also tracking how you've paid it. So if you're issuing a check, make sure to issue it and send it in a form that you can have ensure delivery. Also, make sure that maybe you make a copy of the check. Inadvertent stuff happens all the time, and because they're taking such a hardline approach, you don't want to be caught off guard if you thought you sent off a timely payment and then the arbitration company says, oh, we never received it, because you send it via mail and there's no delivery confirmation, no way to track whether or not it was actually received. So that's just kind of my add-in on that one, because California is definitely aggressive with that. And going with the other recent arbitration decisions, we're also seeing that California courts are frequently refusing to enforce arbitration agreements because they find them to be unconscionable. So, when a court looks at whether or not an arbitration agreement should be enforced, they look about whether or not it was procedurally unconscionable and substantively unconscionable. So procedural unconscionability, that analysis includes how it was provided to the employee. Most of the time, arbitration agreements are provided on a take it or leave it basis. You got to sign this in order to be employed here. And that sometimes can be okay, except for other times, when employers might not give the employee an opportunity to review the agreement, or they might give the agreement in a language that the employee does not read and fully understand, or they don't give the employee an opportunity to ask questions. So one of the first examples here is Nunez v. Syed Management LLC. Is a 2022 case where the California Court of Appeal refused to enforce the arbitration agreement because they believed it was procedurally unconscionable. So the employee doesn't speak English, and so they provided the agreement in English, and then so he couldn't read and understand the agreement. Also, the arbitration agreement didn't include the fee schedule. And then it was also substantively unconscionable because it allowed the arbitrator to shift attorney's fees and costs to the employee and limited discovery. That's the other part of that analysis, is the substantive unconscionability part, which looks at the terms of the arbitration agreement. So it looks at whether or not it's going to be mutual. So California courts will typically really only enforce agreements that are mutual. So what applies to the employee also needs to apply to the employer. California is pretty strict too about what fees employees can pay for, and also whether or not employers can recover attorney fees in FEHA actions or wrongful termination or under the labor code, and any type of effort on the employer to contract around that's not going to be looked favorably by a court. Ramirez v. Charters Communication has that as a good example. Again, another 2022 case where the arbitration agreement was determined to be unconscionable because it was seen as being one-sided. This goes again to that substantive terms of the agreement. So there was a shortening of the statute of limitations period. There's an attorney's fee provision if you brought a successful motion to compel. And then also there were some issues where the employer got to define the claims differently than permitted under California law. California courts are just not going to take that favorably, and they will refuse to enforce those agreements. Recently, actually in November, there was several California Court of Appeal decisions about arbitrations agreements, and they typically were reaffirming those denials of those motions to compel arbitration because the agreements were either unconscionable or the employer delayed. One of the examples was Mills v. Facility Solutions Group. The Court of Appeal pretty much said, they're not going to rewrite arbitration agreements. So while they'll sometimes sever an unconscionable provision here and there, they're not going to enforce agreements where they're very one-sided. And the purpose of this is to discourage employers from, providing employees with these one-sided agreements. So California courts of appeals have made it very clear that these agreements are not going to be enforced going forward. We also have some other issues with arbitration agreements besides the procedural and substantive unconscionability issues. We also saw this year, Mendoza v. Trans Valley Transport. There was a definitive decision saying that arbitration agreements and employee handbooks are not going to be enforceable. I know that some people try to include arbitration policies in the handbooks, but unfortunately, without a separate arbitration agreement, you're going to have an uphill battle getting that into arbitration if an employee files a lawsuit. We also saw that in DFH v. Cisco Systems, arbitration agreements with employees are not necessarily going to apply to claims brought by the Department of Fair Employment and Housing, which is now the CRD. So because those agencies did not enter into those agreements with the employer, they're going to be able to sidestep those arbitration agreements. So it is important to keep that in mind if you do have employees who have filed claims with the CRD and they're being investigated. If the civil action is brought, you're not going to likely be able to enforce an arbitration agreement based upon DFVH v. Cisco Systems. The next one is Morgan v. Sundance, and that's a United States Supreme Court decision. And this resolved a circuit split regarding whether or not a plaintiff had to show prejudice from an employer or the defendant delaying compelling arbitration. And so there in Sundance, the employer had an arbitration agreement, but waited 8 months after the initiation of the lawsuit to move to compel arbitration. They had filed a motion to dismiss. They participated in mediation. There was a dispute about whether or not the plaintiff needed to show that she experienced any prejudice from this delay. And so the United States Supreme Court resolved this and said prejudice is not required to show waiver. And hopping on this bandwagon in Davis v. Sheik in this past month, the California Court of Appeal also reaffirmed that prejudice is not required to show waiver of the right to compel arbitration. So it's really important if you get claims coming in from employees that you look to see if their personnel file includes an arbitration agreement. And if you do, then making that decision at the outset of whether or not you want to put this in arbitration versus, seeing how the litigation goes, or if you can resolve it early, because the longer you wait, the likely you might be waiving your right to compel arbitration. Now I'm going back over to Olga with our whistleblower retaliation.
Yes, thank you, Allison. So we're going to move to this last set of cases fairly quickly. I know we're running a little bit short on time, but we want to make sure we get the information over to you. So whistleblower retaliation. So under the California, we have the federal whistleblower protection laws, United States laws. Under the California Labor Code, an employee can also sue for whistleblower retaliation if they're terminated, demoted, et cetera, for complaining about a labor code violation. And so there was a little bit of a legal question that went up all the way to the California Supreme Court, which basically asked, okay, so if an employee sues for whistleblower retaliation under the labor code, what exactly does the employee have to prove? And the reason that that was even a question is because there were two potential tests that the court could apply in deciding whether the employee proved his claim or not. One of them was a little bit more employer friendly. It's this McDonnell-Douglas burden shifting test, where the burden basically goes back and forth. The employee establishes a prima facie case of retaliation. Employer gets to come forward with legitimate non-retaliatory reason for its action. Then the employee must prove that that reason is pretextual in order to win the case. And then there's the much more employee-friendly test, where all that really needs to happen is that the employee needs to show that his protected activity, his complaint about a labor code violation, was a contributing factor, not the only factor, but a contributing factor to, let's say, the termination. And then it comes back to the employer to show by clear and convincing evidence that they would have terminated the employee anyway, even if the employee hadn't made that complaint. So that test is a lot easier on the employee and a lot harder on the employer. Surprise, surprise. The California Supreme Court said that that is the test that applies in these whistleblower cases, which of course now makes it easier for employees to prevail on retaliation claims and makes it just that much more important for employers to have really well-justified, well-documented reasons for any adverse action, terminations, demotions, pay cuts, etc.
Just to add to that, what Olga was saying there, the statute, the Labor Code 1102.5, a couple of years ago created a private right of action. It used to be the labor commissioner could enforce it. Now it's individual employees, former employees. And a year later, the legislature added attorney's fees recovery to a prevailing whistleblower claim. So that's going to be, I predict that's going to be a huge expansion for employers, more retaliation claims.
Absolutely, especially under this easier standard. So now the good news, of course, is just because it's an easier standard for employees to satisfy, it doesn't mean they win automatically. And so fortunately, even as recent, as quickly as within the same year that this new Supreme Court decision came down, we did at least get one California Court of Appeal decision where the employee lost, even under this easier standard. And the reason the employee lost in this case, the Batalaro case, is, so here the facts were pretty straightforward. The county terminated the employee from a promoted position after concluding that she didn't successfully complete probation. The employee sued, claimed that she was demoted or terminated from the promoted position because she had complained complained about working below her service classification. The court applied the employee-friendly test, but still found that there was no retaliation because the employee hadn't actually engaged in protected activity. So in order to prove that you engaged in protected activity, you have to prove that you complained about a legal violation. What she complained about was just an internal personnel matter. So it's not like it's impossible for an employer to win in a case like this, but it is definitely harder. A few more decisions to cover quickly, Allison.
Yes. So I will not try to go too fast, but there's a couple other big decisions this year that we think are important. So Graham v. Eisenhower is an important decision because a lot of companies in California use temporary staffing agencies to fill in their labor at their workplace. And here, the plaintiff had filed a class action against the temporary staffing agency, settled that class action, and then like a little bit later, filed another lawsuit against the medical center that she worked at through the temporary staffing agency. So the medical center tried to dismiss the case based upon this prior settlement. The California California Supreme Court denied that based upon the fact that she had been the settlement agreement did not include the medical center in there. So it's important to keep in mind when you're working with vendors like temporary staffing agencies or any other type of vendor that you're working with them if they do have litigation to make sure that they're kind of covering your bases, because there is some indication based on this decision that if the release had included the medical center, that the outcome would have been different and the medical center wouldn't be facing this class action lawsuit or that. So after that, we have Allen v. Staples, and this is under the Equal Pay Act in California. So under California law, employers are prohibited from paying employees of the opposite sex a different wage rate for equal work in the same establishment under similar circumstances, except if there's like a merit system, a seniority system, or another method of payment based upon like quantity or quality of work, or another bona fide factor that does not consider sex or gender. In this case, the plaintiff had filed a claim under the Equal Pay Act. Interestingly enough, the employer won a summary judgment motion, but it was appealed, and they determined that there was a triable issue of fact, because even though there were several other female employees who did make more than their male counterparts, the plaintiff was able to identify one male employee who was working in the same position and it would have been a comparable identifier. He made more than her, and unfortunately, the company did not put forth the evidence that this individual employee actually was being paid a different wage rate based upon merit, seniority, or experience, even though that the company did show that their payment policies were based upon that. So I think the biggest lesson learned from that case is that when you're making payment decisions or pay decisions, including merit increases and bonuses, to document for each employee the reason for that decision versus a broad policy, because if you do have an Equal Pay Act claim, you're going to need to show why two employees specifically were being paid differently, not just a policy and practice that you've implemented in the workplace. And then taking that back over to Olga.
Suitable seating. So the Industrial Welfare Commission Wage Order 7 requires employers to provide suitable seating for its employees in certain positions. An employee sued AutoZone claiming that suitable seating was not provided. AutoZone goes, well, of course, what are you talking about? We have a policy that says that anyone can have a chair. We have 2 raised chairs available. The court said, well, yeah, but that may not be enough. First of all, I don't think employees were actually expressly advised that they're entitled to use these chairs. The chairs aren't actually located at the workstations. They're standing over by the manager's desk at the other side of the store. So employees may not necessarily even know they exist. They're not visible or readily accessible. So under these circumstances, there might be a violation in spite of what the company policy may say. So employee didn't necessarily win, but the lawsuit was allowed to continue under these facts. And then a real quick mention of a case under the Fair Credit Reporting Act. So as you probably know, if you're going to be running background checks, there's certain very specific disclosures that are required by the FCRA, and even just a minor violation of what the content is supposed to be in those disclosures, if it was willful, intentional, it exposes an employer to potentially a huge amount of penalties if it's a class action involving 5,000 employees. In this particular case, there was definitely some sort of extraneous non-permissible information in the FCRA disclosure. The employer said, well, this can't possibly be a willful violation because this was just a drafting error. It was clearly not intentional. And the court said, no, it could be willful because, first of all, at least one employee was aware that there was this incorrect or extraneous information in the disclosure, and you may not have had a good system in place to monitor compliance with the FCRA. Under those circumstances, it could be willful. So we are going to allow this case to proceed.
Okay. So going next to a labor code section that I don't think is on everyone's radar, but labor code section 970 concerns to having employees relocate for employment and based upon false misrepresentations about the kind and nature or duration of work. And in this case, the plaintiff had relocated from Washington, San Francisco for this job with the company, and shortly thereafter, his position was eliminated, and his job position was moved to Bulgaria. So the employee sued because he said during the interview process, there was lots of representations made to him regarding the fact that he was going to be working there long term, that they were looking for his type of position, that he was supposed to help reorganize. And so all these representations and conversations that he had, give rise to this labor code section 970 claim. And so the company said, we had this at-will employment disclosure, so therefore he could not have reasonably expected, employment for a certain period of time. And, the Court of Appeal agreed, at-will employment, is going to show that he did not have a reasonable expectation of like a long-term employment because his employment could be terminated at any time, either by his choice or by the company's choice. However, there were still other false representations regarding the kind and nature of work. So I think the important takeaway, though, from White v. Small is that when you're in the interview process and you might have employees be relocating for this position, be careful what kind of representations you're making concerning those positions. Also make sure that you're in the offer letters and other sorts of documents that are being presented are very clear about the expectations for the position. And, an at-will acknowledgement is not going to be the end-all be-all if you are making a representation and they have moved or relocated for your job position. And last but not least is Manuel v. Superior Court of Santa Clara County. This involves a plaintiff that was allegedly terminated for their undocumented status. The plaintiff alleges that he was terminated because he had a workplace injury. The employer wanted to support its defense that they terminated the plaintiff due to his undocumented status and sought discovery on that issue. In California, though, discovery is not permitted on a person's immigration status unless there's clear and convincing evidence that it's necessary related to the damages that they're seeking. So the plaintiff would have needed to allege that he wanted to be reinstated for his position or that he wanted back pay in order for the defendant to seek discovery on the immigration status. And here the Court of Appeal said that because that's not the issue, he's not seeking back pay and he's not seeking reinstatement, the fact that the employer is asserting this defense that they terminated him because of his undocumented status is irrelevant. So, sorry.
Irrelevant other than the reason for the termination.
Right. Can't help that, but yeah.
Well, thank you, Olga and Allison. That was quite a whirlwind tour of California law. It's amazing what you could cram into 45 minutes. By the way, Olga talked about Labor Code Section 970 and California Labor Code Section 970. I refer to it as the Grapes of Wrath statute because it was passed around the time that people were migrating westward. It significantly includes double damages if you defraud an employee into moving to California or outside of California into California, and statutory attorney's fees. So that's a dangerous claim, even though it's been on the books for a long time. I could see also from that tour of California law, there's a lot more going on in California than just wage and hour. The other thing I would say, I'm a student of history, and history tends to repeat itself. What California passes, those people in other states are not home free. it has a tendency to spread to these other states. You'll see these new California laws emerging in Illinois, New York, Massachusetts, you name it. It's going to spread eastward, for better or for worse. So I'm just going to introduce my colleague, Mike Mata is here. Mike has become an expert on wage and hour law, and that's what we're going to focus in on our presentation. Before we get to that, we're going to do something a little bit different for this program. And there's a poll question up there. The idea is if you rank these or vote for your top topics, we're going to address those at the end in a Q&A format, a more interactive format. So the topics are there: COVID-19 in the workplace, safety guidelines, leaves of absence, litigation trends. Number 2, addressing and investigating workplace complaints. Number 3, managing accommodation requests. That's disabled applicants and employees and the interactive process under the law. Number 4, top wage and hour risk areas. 5, best practices for managing employee performance. That includes evaluation, counseling, improvement plans, motivating employees, discipline. Number 6, best practices for managing a employee termination. Number 7, protecting your intellectual property, trade secrets, proprietary information. How do you prevent that stuff from walking out the door to a competitor? And the last but not least, a very important topic these days, managing a remote workforce. The legal risk and best practices. Obviously, it's different when your workforce is out in the field or they're working from their garage, like I am. Or somewhere else that's not as much controlled by the employer. So if you can all weigh in with your preferred topics, we're going to try to get to as many of them as we can, but we'll probably take the top 3 or 4 and focus on those. So I have my favorites, but I'll let the audience decide that. Okay, so it looks like we have the results here, the poll results. And managing and investigating workplace complaints came in number 1. Managing a remote workforce, I think number 2, if my math is correct or my bar graphs. And then we have, looks like managing accommodations, ADA. I'm glad to see that COVID came in second to last. So we're going to address those topics in our next session. And Olga and Allison will be joining Mike and I to discuss those topics. Okay, so now we're going to turn to everybody's favorite topic, wage and hour compliance, PAGA, Private Attorney General Act, class actions, wage hour class actions, and the many other developments in this area that never seems to die, never seems to go away. Let me just introduce Mike a little bit better. He came to us from the dark side. We recruited him from a plaintiff's class action law firm. He saw the light, and he came over to represent employers, the good, the pure, and the righteous. So we're happy to have him on the team. I use Mike to call my friends on the plaintiff's side to tell them they got no chance of winning. There's not a good case. Right. You got better things to do, right?
Exactly. Waste your time.
Mike is a proud graduate of UCLA Law School. Go Bruins. And he also, I was reading his bio last night, is conversational in Arabic. And right. We have a few clients in Saudi Arabia. So next time you're coming with me, we need somebody to help culturally and with the language.
I will do my best.
Barrier. Okay. With that, we're going to start in with wage and hour. So the first case that I'm going to talk about briefly, you've all probably heard about this case, Viking River Cruises. This case is significant because for a long time, California employers were wondering, how do we get rid of these class actions? What's the silver bullet? We had some favorable California decisions on FAA preemption, the Federal Arbitration Act. This case decided in June of 2022 by the U.S. Supreme Court held that the Federal Arbitration Act preempts a rule of California law that invalidates arbitration agreements containing waivers of the right to assert PAGA representative actions. As many of you know, PAGA was actually enacted in 2004, but it really didn't gain traction until about 10 years ago. And it allows a single employee, current or former, to sue on behalf of aggrieved employees for statutory violations, penalties, civil penalties. So this Viking River case is significant because it did give employers somewhat of a silver bullet. It's important if you're going to choose arbitration, especially for larger employers, to do it right. We can have a whole separate webinar on the pros and cons of arbitration in the employment context. But if you're going to do it, it's important to do it right, to incorporate the FAA in your arbitration agreement, to include the arbitration of all claims under the sun, including PAGA claims, to specifically mention that in your arbitration agreement. The next, so that's Viking River, the Supreme Law of the Land, U.S. Supreme Court. Next case I'm going to talk about briefly, Cadena, if I'm pronouncing it correctly, versus Customer Connects, LLC. This case is significant, in our world, at Wage and Hour, for holding really for a new twist on Wage and Hour. The time spent booting up and logging off of a computer, in this case, the court held, was integral and indispensable part of the employee's duties. So that was compensable time. It's interesting. This is a Ninth Circuit decision. The district court, the trial court, found that, and this was reversed by the Ninth Circuit, but the district court found a very common sense approach to the problem, said the electronic, the logging on to a computer and logging off is, quote, the electronic equivalent of waiting in line to clock in or out of a physical time clock, which is non-compensable. That's the common sense approach, but the Ninth Circuit disagreed. And the Ninth Circuit didn't hand the employee a win, but they said the employee had raised enough evidence to create a triable issue of fact on whether that time was compensable. In our world, triable issue of fact means you're going to a jury, you're not getting out on summary judgment, and it adds to the risk and exposure in these types of cases. So the lesson is, especially in California, there's no de minimis exception under California law. You have to pay for every minute worked, as you'll see when we cover a few more cases here.
That's right.
I'm going to turn it over to Mike to talk about
thank you.
Naranjo.
And Cadena is in a long line of cases that have come out in the past year that are, really showing how strict courts are being in terms of interpreting existing laws and really just strict compliance on employers. Naranjo similarly kind of is in line with Cadena. It's a little bit of a different issue. Naranjo was a class action alleging meal and rest break premium violations, lack of employers paying the premium payments, and then of course the derivative claims for waiting time penalties and wage statement penalties. And really the main ticket item that came out of this case was that meal and rest break violations and the related premiums are actually considered wages. And what that means is they not only have to be reported on wage statements, they need to be paid in full within the statutory deadline for all wages due upon separation of employment. And the court's reasoning here was really that premiums are not just intended to provide compensation for the missed meal period or rest period, but that they're really for the work that the employee performed during those periods. So really the main takeaway that we get from Naranjo is that these are wages. Meal and rest break premiums are wages, and they need to be paid out correctly and listed on wage statements. And we'll see that these new rules have implications on later cases as well.
I would just add, Mike mentioned the waiting time penalty claim in California. If you don't pay all wages, if it's a involuntary termination the same day as the termination, a voluntary resignation within 72 hours, you'll get a claim, or you could get a claim for waiting time penalties. That's 30 days of wages until paid, up to 30 days maximum. So it's very important to include missed meal and rest premiums in the unpaid wages or the wages that are due when you're terminating an employee. Otherwise, you're handing them a claim.
That's right. Next, we'll be talking about Camp v. Home Depot USA, Inc. And this was also another class action alleged against Home Depot. And the main allegation here was that, even though Home Depot's timekeeping system, electronic timekeeping system, captured virtually each second that an employee worked, their policy of quarter-hour rounding the hours worked resulted in employees being paid less than the actual time that they did work. And the 4 key points that come out of this is that first, California requires employees to be paid for all work performed. Again, a new line of cases that really shows how strict courts are being in interpreting what all work performed really means. Second, the regulatory scheme for wage statutes and wage orders focuses on small things, including small amounts of work time. Again, related to Kadena that we talked about earlier, that that startup time is really really important to be focusing on in terms of compensating employees for that time. Next, although federal regulations specifically allow for rounding, no California statute or wage order has impliedly adopted this averaging practice. And again, this is similar to what Tyler had mentioned earlier about the de minimis doctrine. Even if if it seems like there might be some administrative hurdles when making sure the employer is paying out employees for each minute, it's really important that they do so because it can lead to these widespread class actions. So again, the takeaway here is really avoiding all rounding methods when tracking employee time, even if it results in increased wages to the employee.
I think this also is one of those cases that maybe you'll agree, Mike, sometimes bad facts make bad law. And in this case, it was undisputed. The court said it. Home Depot conceded that Camp had lost a total of 470 minutes over approximately 4.5 years due to the rounding policy. So right on its face, you failed to pay the employee for all hours worked.
Right. And there were even some facts that Home Depot tried to rely on where I think several employees were actually overpaid for the amount worked based on that rounding policy. But again, I think the court was really emphasizing that it doesn't matter if the policy is facially neutral, whether in policy or in practice, that it's just a prohibited practice.
The next case, I think Mike is going to cover another bad facts make bad law.
Yes, exactly. This this one really is something that employers need to focus on in terms of paying out regular wages, overtime wages, because according to this case, individuals can now be held liable for unpaid wages and penalties owed to former employees. And again, the facts here were quite egregious. I think the plaintiffs were 2 individuals that lived in a rental unit and agreed with the defendant who owned these rental properties to they really engaged in a little bit of a barter system where they agreed to kind of take care of the premises, handle kind of maintenance duties, and they would receive free rent. Initially, after these plaintiffs were terminated for allegations of misconduct, of course, they were still entitled to bring wage claims against their alleged employer. And both the labor commissioner and the court found that LaPale, the owner of the rental units, was in fact the 2 plaintiffs' employer. And because of that, there are obviously a lot of derivative claims that they can now bring, including those regular and unpaid and overtime wages, those waiting time penalties, wage statement violations, et cetera. And, again, I think the big ticket item is that the fact that an individual can be held liable for these things. Employers want to make sure that they're paying for these wages and meal and rest break premiums. So
one thing that's maybe not covered as much in the media on this new case, The court said, remember I talked about waiting time penalties, that's under Labor Code Section 203. And the court on their waiting time penalties held that the employer failed to include the value of these plaintiffs' housing in calculating their daily rate of pay.
That's right.
So that's a new one I haven't seen before. Not just the hourly wage, but the value of their housing, their rental units that were the employer provided there. I would say, just as a risk management perspective, it's not generally a good idea to rent housing to your employees, because you run into problems like this Sevier, I can't pronounce it, but Sevier Elof case.
Right. Even if you think you're being nice, it's not a good idea.
No good deed goes unpunished in our world.
Right.
You want to talk about Benton Court?
Yeah, exactly. And so Benton Court, I'd referenced previously when we were discussing the Naranjo case. We see how Naranjo plays out in terms of greater exposures to employers with respect to statutory attorney's fees. Like we covered in Naranjo, meal and rest break premiums are considered wages, and because of that, plaintiffs' attorneys are entitled to seek attorney's fees in connection with those claims. In this case, the Benton Court, the plaintiff had settled his claims with the defendant, but as a part of the agreement, the plaintiff was entitled to seek attorney's fees. The defendant argued that the plaintiff shouldn't be able to do so, but again, because of Naranjo, because of those meal and rest break premiums, which were included in that settlement, were considered wages. Now their attorneys were entitled to seek those attorney's fees.
And attorney's fees, and the premiums are wages.
Exactly.
Statute says premiums or penalties, it's actually wages.
That's right.
So the last case that we'll flip over to new legislation is this Callahan versus Brookdale Senior Living Communities case. And this is really one for the litigators out there in the audience. What we're seeing, at least in California, is a lot of copycat claims. I swear that the plaintiff's bar must be monitoring the new filings, just like the defense lawyers sometimes do, to pitch for new work, new cases. And they see a wage hour class actions filed against one employer, and you get the copycat claim. We get the class action lawsuit and then a separate PAGA lawsuit to separate them out. It's almost like they're trying to make life more difficult for our California employers. And this is a good tool really for litigators. Once you're sued on a wage hour claim, whether it's a PAGA action or a putative class action. I say putative because it's not a class action until the judge agrees. All of them are putative, attempted, purported. They're not class actions until the judge agrees. So with this trend of overlapping classes and cases in different forums, different courts, this court case is significant because employers can settle the first one, you go to mediation, you resolve it, and use it as a defense or even a bar to the copycat claims. In this case, there's a long discussion about permissive joinder and necessary joinder. The bottom line is the subsequent PAGA plaintiff did not have standing to pursue this claim. It was duplicative, and the prior settlement was used, and the Ninth Circuit affirmed this decision to bar that subsequent plaintiff. So it's really not so much for HR, but when you get a case, how do you deal with it? How do you minimize the expense to the employer and try to consolidate or even dismiss or stay a copycat claim? With that, Mike and I are going to talk about wage and hour legislation, new laws for 2023. I might add, we have prepared a more comprehensive list of all California new laws for 2023. And I don't think we included it in our materials, but if anybody wants that, just send us an email. We can send it along. It's a lot longer list than we could cover here today. So with that, this is mine. I was going to do a poll of my own, but the answer's already out there. I was going to ask people if they knew if this minimum wage in California applies to all size employers, and the answer is it does. It used to be smaller employers were accepted. This, and this is a trend that we're seeing in California. what I call one size fits all. Olga mentioned earlier with the CFRA, if that's how you pronounce it, California Family Rights Act, now being reduced to 5 employees, you're eligible. We're seeing that as a trend. It used to be 50 employees. They're trying to catch more employers or cover more employers under these laws. Same thing with minimum wage, $15.50 an hour, regardless of size. There's also this increase in the salary necessary to qualify for an exemption. So it's up to $64,480 as of January 1, 2023. That's real money. It used to be, I think, like $23,000. I think I'm dating myself now, but it goes up with the minimum wage and the cost of living adjustment. And finally, the white collar exemptions, that's the executive exemption, the administrative exemption, the professional exemption, the white collar exemptions from wage hour, overtime payment are attached to the state minimum wage. Whenever the minimum wage goes up, that white collar salary threshold is also going to go up. A trap for the unwary employer.
And one other item, just be sure to look at the minimum wage that's in your own or where your employees are situated, which county they're located in, because different counties do have their own local ordinances that dictate what the minimum wage should be and is, and sometimes in different counties in California, it is actually higher than $15.50.
That's a good point. We saw during COVID, many counties and municipalities enacted their own COVID protections, like Santa Clara County, where I'm based, had a very stringent COVID requirements. Same thing here. Look at the local ordinances, Los Angeles, Oakland, San Francisco, I guess now West Hollywood as well. Right. San Diego is another one to watch out for. I would turn this California AB 257 over to Mike.
Thank you. Yeah, this is, you've likely heard about this one before. This is the Fast Food Accountability and Standards Recovery Act, otherwise known as the FAST Act. I think this took over the headlines in every major news outlet for at least a week. This new law really, it creates a fast food council, and the purpose of it is to set minimum wages and minimum standards that are applicable to all fast food restaurants that are part of a chain of 100 or more establishments nationwide. They are given a lot of authority to raise minimum wages for fast food employees to up to $22 an hour in 2023. They might also increase minimum wages each year thereafter. This law also prohibits fast food chain employers from and restaurant operators from discharging or discriminating or retaliating against any employee who has made a complaint or disclosed information regarding a public health or safety issue with respect to that restaurant, if they have participated in a proceeding relating to employee or public health or safety, or if they refused to perform any sort of work because they believe it would violate any public health or safety law. And this, this language is similar to, classic retaliation language we have otherwise in the labor code. And one of the ambiguities that's in this law that I suspect we'll see in litigation down the line is the definition of fast food restaurant isn't quite clear. It's unclear whether coffee shops or ice cream shops, things like that, will qualify as a fast food restaurant, and thus may be within the purview of the statute. So I think down the line we'll likely see some more clear interpretations of what fast food restaurant really means.
Mike, any idea about the penalties or remedies for violations of the new law?
There are penalties. I don't believe the civil penalties have been clearly outlined just yet, but there are definitely penalties for employers who violate this law.
It's kind of like some bills in Congress. You got to pass it to see what's in it.
Right.
Right, to see where it covers, right, or who it covers. So another trend of the one-size-fits-all is this new SB, by the way, that means Senate bill. AB means Assembly bill in the California legislature, so SB 1162. This is very significant. I I think, the most significant new law in California. It's designed to combat the discrepancy between women in the workforce who are paid less historically than men, and if it is designed to avoid perpetuating those disparities. So this new law imposes additional onerous requirements, administrative requirements on employers. 15 or more employees must publish pay scales, information for every job posting that is a position that's being filled. Employers must provide that information to employees and job applicants upon request. And for those private employers with more than 100 employees, they submit an annual paid data report to those. We heard this new acronym. For 33 years, I knew about DFEH, now it's CRD, new acronym, Civil Rights Department in California, formerly the DFEH. And you have to submit that pay report to the CRD now in May of every year. So it's a new burden on employers. We're still kind of deciding or helping employers comply with this, and there's a little bit on uncertainty on some of the provisions, requirements of this new law.
That's right. And again, there are also penalties for violations for, at least with respect to the pay disclosure. I believe it's anywhere between $100 to $10,000 per violation. Although the statute does have a carve out if the initial violation appears that it's a good faith mistake and the employer did not intentionally refuse to disclose the pay scale, then there wouldn't be any sort of penalty. Again, that's for the initial violation.
Okay, good to know there's still a good faith defense.
Right.
Whether it will be applied in practice is another question.
Right, we'll see.
So next one, SB 1126. This is, California has this Cal Savers program. It used to have an employee threshold. Again, one size fits all. There's no longer a minimum number of employees that is required to have to maintain a retirement savings account for your employees. So this expands the definition also of eligible employers. So yeah, that's something, if you don't have a retirement plan, to keep in mind going forward. This also has a December 31, 2025 deadline to make this payroll deposit savings arrangement to allow employee participation. So that's Cal Savers. A lot of people have never heard of it, but I'm getting a lot more questions about it as a result of this new law. Next one, Mike, you want to talk about SB 1334?
Absolutely. This really just extends meal and rest break period regulations to hospital employees, specifically public sector hospitals employees. So originally, I should say, meal and rest break regulations set forth in the labor code really were just applicable to private sector employers. And now it's extending those regulations to public sector healthcare employees who provide direct patient care or support direct patient care in general, acute care hospitals, clinics, or any sort of public health setting. And these public sector healthcare employers include the state of California, municipalities in California, and the regents of the University of California. So this one's quite straightforward.
And next is AB 1851, Public Works.
And again, this one is quite straightforward as well. It's extending really just the definition of what public works means. Originally, it was a more narrow definition, but now the definition expands to, and this is for the purposes of paying out employees their prevailing wages. It expands to include the on-hauling of materials used for paving, for grading, and fill onto a public works site if the individual driver's work is integrated into the flow process of a construction. So again, keeping in mind what job duties these employees are really partaking in, and then considering if these kind of duties are in line with their actual work, then making sure that the prevailing wage rate is applied to any work that they perform.
All right. Another law here, SB 954. You want to cover that one?
Yeah, absolutely. And again, this is really an extension of existing law. Originally, the current law states that contractors and some subcontractors have to supply the labor commissioner with payroll records concerning public works projects. Now, the Department of Industrial Relations has to establish an online database of electronic certified payroll records. And again, this is kind of in line with what California has been doing recently in terms of providing pay transparency and holding employers accountable for publishing all data that they have on employee payroll.
There's also, some of you may be aware, in the labor code, I believe it's 232, prohibits employers from telling employees they're not allowed to discuss their wages. So, you think another common sense thing, we don't want you out there talking about your comp and comparing it to your neighbors, but that in California is not allowed. They're allowed to exercise those rights to talk about their compensation. You can't keep it strictly confidential, and these laws are in line with that trend.
That's right.
I guess we couldn't escape without talking about COVID,
Our
right?
favorite. Exactly.
So especially when it's not on our list of favorite topics.
Right.
So we'll cover this quickly, and then Olga and Allison will join us. So Mike, you want to talk about SB 152?
Yeah, this really just extends the amount of time that employers are obligated to provide employees with supplemental paid sick leave. It doesn't create any sort of new bucket of leave. There are really just two buckets of 40 hours. The first bucket of paid leave of 40 hours is for any sort of qualified COVID qualifying reason. And there's a second bucket of 40 hours as well for positive COVID tests. This really just extends the time in which an employee is entitled to payment under the SPSL until December 31st, 2022. And again, employers are, they do need to remember that local ordinances remain in effect in places like Long Beach and Oakland that have their own SPSL leave policies. And as amended as well, employers can require that employees who test positive 2 times take a third diagnostic test. And if they refuse to take that third diagnostic test, the employer can deny the SPSL leave.
Okay, quickly on SB 2693, this, another COVID-related exposure notification, amends the labor code duties of employer when notified of potential exposure, extends the provisions until January 1, 2024. You have to notify the local health agency. Notice was required in the event of an outbreak, which is defined under the statute. The California Department of Public Health, another acronym, CDPH, will no longer be required to make workplace industry information regarding COVID-19 outbreaks and cases received from local health departments available on its website. I guess that's too much of an administrative burden for the government. And the employers will have an option of posting a notice of potential COVID exposure in the work site.
And then
last but not least, AB 2068, COVID workplace posters in different languages.
Right. So currently, employers are required to provide notification to employees regarding any sort of workplace health or safety citation or order when it's issued by the Division of Occupational Safety and Health. Now those notices need to be published in the top 7 non-English languages used by limited English proficient adults in California. And that includes Spanish, Armenian, Cantonese, Mandarin, Korean, Vietnamese, and Tagalog. And the notices are also required to be posted in Punjabi if that is not one of the top 7 languages. And again, this is in line with California, making sure that employers have access to records and information and efforts towards transparency. So,
and there's a civil penalty.
There is a civil penalty, so
okay.
You are encouraged to follow this quite strictly.
So with that, we're completed our wage hour update. And now we're going to have Olga and Allison join us. And hopefully somebody can remind me of our top 4 topics. This is where the part of the program where you're encouraged to stand. We're not taking formal breaks, and stretch your legs. And I'm told I'm supposed to fill this with something interesting. So what do you think about the Michigan-Ohio State football game, the big game on Saturday? And follow-up questions. Should Ohio State be in the top 4? That's I'm throwing that out there to the audience for those who are sports fans. So just to go over again the topics, I think the number 1 was managing. I'm sorry.
The remote workforce.
Remote
Yes.
workplace. Okay, so let's start with that, and I won't pick on anybody, but Olga's volunteering.
I volunteer. I volunteer as tribute. This was not pre-planned. So, which, by the way, doesn't mean I'm putting the onus on myself to tell you everything you need to know. I'm literally going to just flag some issues and then cold call on people. So managing a remote workforce, something that I'm sure everyone's become all too familiar with at this point, even now that we've more or less returned to normal life post-COVID to a certain extent. A lot of employers and employees have realized that they like the remote arrangement. They like being able to hire folks that are not necessarily within their limits of their state. There's a greater candidate pool that way. Some money an overhead is saved on having folks work from home. So there's definitely a huge amount of advantage to having a remote workforce, but there are definitely also issues that employers have to be very cognizant of. I'm going to flag just a couple of the main issues that jump to my mind, and I'm going to open it up to my brilliant panel here to give you their top tips and their ideas on how best to address these issues. So I really have 3 issues that come to my mind almost immediately on a remote workforce. First of all, choice of law. So usually, on most circumstances, an employee's employment is going to be governed by the state where the employee is located. So if they're a Texas-based company and you've got a remote employee that works exclusively from California, chances are you are going to have to comply with California law with respect to that particular employee. And that becomes really tricky if you've got a remote workforce where you've got a single employee in 17 different states. It definitely creates an onus on you to know the law of states that you may not necessarily have had to know in the past. So that's a big issue. Issue 2 is how to monitor the behavior of an employee over whom nobody has immediate oversight, right? If you got an employee who's working remotely, what do you do to ensure that that employee is complying with all company policies, that the employee is not engaging in any kind of misconduct that would violate company policy while at home? Does the employee have a safe workplace where they might not inadvertently injure themselves and create a workers' comp issue? How do you determine that? How do you figure that out if you don't know where they're working and you have no control over the setup of their home? What do you do with hourly non-exempt employees? These employees need to track their time. They cannot work off the clock. They need meal and rest breaks. What do you do to ensure that all timekeeping, break, overtime requirements are accounted for and complied with when you don't have immediate control over the non-exempt employee's work area? And then expense reimbursements. How do you ensure that employees are reimbursed for any work-related expense such as phone use and internet use? And then the final issue I'm going to flag is how do you protect your intellectual property? You have an employee who's using, even if it's a company laptop, but you've got an employee who's working remotely, they're bringing in your proprietary, confidential, and trade secret information into their home. How do you ensure that there's adequate safeguards in place to make sure that that IP isn't lost, disseminated, thrown into a trash can without being shredded and picked up by someone, a member of the general public? So those are the issues that really hop into my mind most immediately. So what does everyone think? Does anyone have some fantastic tips on how to address all these various complicated matters?
Yeah, so I would say, before COVID and we just had telecommuting agreements, we would have to provision for what happens if a workplace injury isn't ergonomically correct. We might have to inspect the workplace. It's kind of hard to do that now with everybody working remotely. So the 2 big issues I see are if you as an employer are allowing your employees to work remotely, it's going to be hard to say in response to a disabled employee's request to work remotely that being at the office is an essential function. If 90% of your workforce is working out there in the field, you're not going to have that defense that being at work is an essential function. Or it's going to be harder to assert that as a defense. Another big issue I see lurking out there for California employers is expense reimbursement. I see class actions, PAGA actions for failure to reimburse for computer modem, the printer, scanner. We already have prorated share of cell phone expenses, and the law in this area in California is not very well settled. We have an older case, I think from 2014, Cochran, which basically says you pay the employee, reimburse them for cell phone expenses in a reasonable amount. I like when they use reasonable. It's a litigator's dream. So that stuff is coming down the pike. You want to have policies in place. With expense reimbursements, you can have a lump sum reimbursement. You want to have a method. If an employee says, hey, I didn't get, I'm short $10, you want to have a method to true that up at the end of the month. So you're not, that liability is not continuing. You have a mechanism in place to make the employee whole on expense reimbursements. Those are my two big things.
Well, to add on to the expense reimbursement, and kind of this is a little bit different, but the employees working from home remotely, like full time, and that's their assigned location, and then you're asking them to travel to an office location at some point in time, and you also have to start considering to any mileage. Generally, pre-pandemic, when we all used to travel to the office on a regular basis, commuting time and mileage to commute to and from work was not going to be something you had to reimburse for. But if you have people who are working full-time remote and that's their destination, then you start requiring them to travel, you need to consider those other additional items. And then, having a policy that's well developed and thinking through what is a reasonable amount to provide. So that goes also to the whole entire BYOD, bring your own devices, which also kind of dovetails back to what Olga was talking about, is how do you protect your intellectual property? You're giving them all this proprietary confidential information. If you are requiring your employees to provide their own laptops and to provide their own cell phones and all these other items on their own, then you're going to have to try to get that back from the employee or your information off of those systems at the end of their employment, but also you're going to have some expense reimbursement obligations. And so employers hopefully by now have taken that time to kind of, go through the analysis of what would be more advantageous for them to provide, the employee with their own laptop, the cell phone, the printers, or to require the employee to purchase that and then maybe do some sort of reimbursement. And so going from there too, if you do have your own laptops and things like that, how are you going to make sure that the employee returns that at the end of the day, having a policy and practice for maybe an exit interview for when employees are leaving to ensure that they have returned all of your equipment, that we returned your proprietary information, confidential information. They don't have printouts at home. So if there's a printer connected, make sure that they've maybe attested, maybe some sort of certification at the end that they provide to an exit interview. And so there's policies and practices I think you want to put in place for when employees are leaving and making sure that that's clear to employees in written policies. So I think those are kind of some important matters. But going back to what Olga also originally said about the geographic location and choice of law provisions, it's really important to keep in mind if you're an out-of-state employer, California has a labor code section. It's labor code section 925 that prohibits employment agreements having choice of law and choice of venue clauses outside of the state of California for an employee who primarily works and resides in California. And, so you take your employment agreement that you use for an employee in Texas or Florida and then give it to an employee in California, and you forget to take out those choice of law provisions or even those non-solicitation, non-compete provisions that you normally apply. And then you're going to have some problems in California because they're not going to enforce all those provisions in your employment agreement, and you're going to be forced to litigate in California too. I've also had this come up in other cases in unique circumstances. I was actually telling Olga about that earlier, is, if you're also not keeping tabs on where your employees are at, it's really important because I had a case where we thought the employee lived and worked in Georgia and, sometimes traveled to New York for business, and turned out they claimed when they filed their lawsuit in San Francisco Superior Court under the California Fair Employment and Housing Act that they alleged that they worked and lived primarily in California and San Francisco. So it was an interesting case, hotly debated. topic for us. And, at the end of the day, I think the biggest lesson learned from that case, at least what I try to tell clients who have remote workers, make sure you have employees who are telling you where they're at when they're working. Make sure they know that there is an obligation to notify you of any changes in your address. That policy that's always in the employee handbook that gets a little short notice about, oh, please update us if you have changes in your address or marital status and that's important in the remote work atmosphere now, because if you have an employee who thinks working in Florida and they're actually working in California because they thought, hey, I can go work in Big Bear for the snow season, or Mammoth, work from a cabin and go skiing on the weekend, you're gonna have some problems if you weren't complying with California labor and employment law, and they decide to go and consult with California labor and employment attorney. Sorry, I'll stop talking and share the floor with other people, but yeah.
Yeah,
Anybody
so
else?
I think that those are kind of bleeds into protecting data. And in addition to what Allison, those are all excellent suggestions, advice. Employees can remote wipe data. If you have a certain software, you can encrypt data. The issue really is once, I call it the toothpaste out of the tube problem. Once your trade secrets are on a BYOD device, somebody's cell phone, their personal laptop, their iPad, how do you get it back? You go to a forensics person and they'll say $15,000 will separate the personal from the work. That's the cost of doing business. You're gonna have a hard time shifting the cost to the employee if you encourage them to use their personal device for work. So that's an issue we see a lot more on the protecting your data issue. But remote work raises a lot of these interesting evolving issues.
And that's where a good remote work agreement becomes absolutely critical. It's something we would highly recommend, because in that agreement you can really lay out all the expectations and have the employee acknowledge and agree to what's expected of them. I acknowledge that I live and work in Georgia, and that I will advise you if I do not live and work in Georgia immediately. I acknowledge that I am bound by the company's harassment policies, workplace safety policies, anti-discrimination policies. I acknowledge that I am expected to accurately record my time. I acknowledge that I need to take meal and rest breaks. So a really good remote work agreement is really, really helpful and really recommended.
Yeah, I mean, that's a good tip for all employers. Just drafting employee handbooks, offer letters, policies, making sure your expectations are clear. It's a perfect opportunity to put your expectations in there, make them crystal clear, and be protected in the event of a claim later.
Oh yeah, definitely. And making sure you revise everything to be compliant with whatever state the employee is working in. Because each state, California, we take lead, or we pride ourselves on taking the lead on employee protections, but we are seeing other states move in that same way. And so if you're not being conscientious of what is going on in those other states, those localities, and not developing a remote work agreement for each employee, thinking through that process, you might be providing them with outdated information or information that might not be applicable. And going back to our arbitration conversation earlier today, stuff that might be allowed in other states might not be allowed here, and vice versa. So it's just really important to kind of make sure that even when you're doing that, you have the process to kind of go through and do a checklist maybe of the major important laws in each locality that you're hiring in. And before you maybe hire a remote worker outside of the state that you typically do business, consider whether or not that's going to be beneficial for you, and whether or not you need to consult labor and employment counsel so that you're in compliance with that. And there's also other things like unemployment benefits that happen in California, workers' comp obligations in California that are going to be different too. And so there's just so many different things we have to take into consideration also.
Yeah, this we could come up with law school or bar exam questions. Somebody is in California, they go to New York, and then they go to Texas, and then they go to Utah. Which state's laws applies when? We could. I guess I put it then on the bar exam at some point. The second of our
It was managing accommodations in the interactive process.
Okay, that's
my topic, by the way.
Okay, so my 2 cents on that. I already mentioned, when you're allowing remote work, it's going to be harder to take the position that this is an essential duty that you be physically on site for the job. It's just harder to make that argument. The interactive process is a mandatory legal duty. So, and it used to be in California, now it's expanded to the ADA. And that courts take that seriously. That means even if you totally disagree with the accommodations proposed by the disabled employee or applicant or by his or her doctor, it's important to go through the motions, to go through the steps of that interactive process. At the end of the day, you could win the case even if you're not able to provide a reasonable accommodation, or there's an undue hardship defense or whatever it might be, just by going through that process. Patience is a virtue.
I definitely agree. Patience is a virtue in the managing the accommodation interactive process. I've been seeing a recent uptick in cases with like leave of absence accommodations. And, when does a leave of absence no longer become a reasonable accommodation? And also, I know under California Family Rights Act, CFRA, or as Olga likes to say, CFRA.
Apparently I'm the only one. So I'm wrong, clearly.
No. To each his own. But under like the CFRA and FEMLA, you do have these obligations to reinstate employees after the end of the 12 weeks, or that the protected time off. California also has other protected time off obligations too. But it becomes a question of what's our obligation to reinstate an employee at the end of their leave of absence, and when does it no longer is it no longer reasonable to hold open their position for them, and what can we do? Because we are seeing these extended leaves of absences that are going months beyond just what they get under CFRA or FEMLA. Other issues that I'm seeing in cases that I know I've been handling is, employees, you email the employee or you talk to the employee and say, hey, we want to talk to you, have this interactive interview or process or meeting or whatever, and the employee responds back and they say, I don't feel comfortable talking to you on the phone or meeting with you in person. And so how do you handle that? Because I think at the end of the day, we all have an obligation to engage in the interactive process. Your employee does, so does the company, but is there an ability for that employee to restrict it to strictly email? And what is a good employer response? And those are things that I've been seeing a lot of with respect to that. I think, I don't know if anybody else has seen anything different, but I also would love to hear you guys' thoughts on that, because I have this come up constantly and I would love some feedback from our brilliant panel. So
yeah, leaves are tricky. I agree with Allison. I mean, because what I'm seeing a lot of in the accommodation process is employers really, and justifiably, by the way, wanting to resist the doctor's note, right? Because you get this doctor's note and you're looking at it and goes, the employee needs 3 years of leave, but then we'll definitely return to work. So no, it's not indefinite. So you have to give it to them. And you're looking at this going, there is no way. And so there is a very understandable desire to question the validity of the doctors, to call the doctor and say, hey, did you, is this really true? Can you explain this to me further? And there is extraordinarily limited circumstances in which you can do that in California. In California, it's even stricter than the rest of the country, because the only circumstance in which you can actually contact the doctor directly to ask them about the note is if you have a reasonable ground to doubt its authenticity, not its accuracy, but its authenticity. So if you look at the doctor's note and it is written in crayon, right? So clearly under those circumstances, you might be able to call the doctor, but only after you give the employee notice and an opportunity to cure the issue. Yeah. So it is virtually impossible to think of a circumstance where you can actually reach out to the doctor directly. And because California has such robust privacy protections, there's a lot of things you can't. You don't have to assume everything at face value, right? Most doctors' notes are not going to have all of the information you're entitled to make an accommodation decision. So you can go back and say, hey, listen, we're missing information. We need more information. Here's our accommodation form, our medical certification form. Please have your doctor fill this out. And until they do this, we cannot make an educated decision on whether we can accommodate you or not. But you're limited. You're very limited in what you can ask for.
Same thing with COVID, inquiring further. That reminds me of I think a kid wrote a note on opening day of baseball that he had an appointment with Dr. Verlander. I guess that would be, you could challenge that as being inauthentic.
Yeah. But no, I mean, I agree too with the advising them of the deficiencies. I think that's so important, is making sure that it's very clear what's the issue with that. I also see the problem too where you get the doctor's note and they put them out on leave of absence for like a month, and then they get another doctor's note next month saying they're out on another leave for another month, and they just do that over and over and over and over again, and like that. And that always seems to be a problem like that, and it's really hard to push back because it's not an indefinite leave of absence still. So
yeah, no, it's really tough. I don't know, Mike, if you've seen anything else other than what we've been mentioning, but those are definitely unique challenges we see a lot. I don't know if you see any others.
Yeah, I think that sometimes employers forget with respect to the interactive process, that it's an ongoing duty. It's not just the initial interaction. As soon as employer is on notice, of course, the obligation is to contact the employee and engage in the interactive process and come up with a reasonable accommodation. But it doesn't end there. And sometimes, especially in the remote world, I think sometimes it's a little bit more difficult to follow up and find out what an accommodation might be down the line if it's an ongoing disability, and keeping in mind again that it's an ongoing duty.
Yeah, very good point.
Back to a point I think Allison made about you have the employee who's saying, I'm not going to talk to you, I'm going to email you. At what point is it too difficult to engage in the interactive process? In an event of a dispute or really a lawsuit, a court has to assign blame for the breakdown in the mandatory interactive process. So you're going to want to document if the employee throws up hurdles, you can only talk at certain times or you can't talk at all. If there's a need to meet with the doctor to get some medical input and the employee refuses, you want to just make that record. So in the event of litigation, you can say the breakdown was the employee's fault. It's a two-way street. So I think but these are vexing issues for all employers.
Yeah.
So I'm glad we're able to provide this 20 minutes of answering everybody's question.
I think we just posed more questions than answers.
Right.
That's our job.
Yeah. You see the issues.
Yes, exactly.
I think was the next one
Workplace complaints and investigations.
Okay.
Yeah, so that's a tough one, right? Because that encompasses any number of things. What do you do when you've got an employee who brings some kind of workplace complaint? And from my perspective, where I see the most difficult piece of this process, hopefully once that complaint, whether it be a harassment complaint, a workplace bullying complaint, anything, makes it into the hands of the person who is, in charge and knowledgeable on how to handle it, the HR person, right, who knows how to conduct the investigation, who knows how to respond. Hopefully that's the area where you're not going to experience as many problems. Where the highest risk area for me, and obviously people might disagree, is getting that complaint into the right hands, because it very rarely happens that a complaint is made through a whistleblower hotline or to an HR rep. The way these complaints usually come up is in passing conversation. One employee says to another, hey, so-and-so made this really inappropriate joke in the lunchroom today and made me really, really uncomfortable. And here's the thing. If any manager or supervisor, either firsthand or secondhand or thirdhand, gets wind of this concern or this complaint or this issue, the company is deemed to be on notice, right? And that could be any supervisor or manager. So the really, really critical point for me in addressing complaints is training anyone who's even arguably in a supervisory capacity to respond to complaints appropriately, to recognize them. Whether it's spoken complaints, or if a supervisor walks into a room and hears someone make an off-color joke and sees someone else looking visibly uncomfortable, anything. So it's so critical for supervisors to understand that when in doubt, even if there's some ambiguity, get the information over to HR, get it over to the right person, take everything seriously, even if it doesn't seem serious to you. You also have to be very careful to teach folks about what not to tell complainants, because how often do we get the situation where an employee comes up to a supervisor and says, hey, so-and-so made me really uncomfortable the other day. They made this really inappropriate remark, but I'm kind of embarrassed. Can you please not tell anyone? And the supervisor, out of the goodness of their heart and their best intention, goes, I will absolutely respect that. You cannot do that. You cannot promise confidentiality. You always have to be prepared to say, look, I'm so sorry, but this is not something that I can keep quiet. I need to get this up to the appropriate persons. So, I can go on for ages about all of these various things that supervisors need to be aware of, but getting your supervisor force trained to know how to recognize and respond to potential workplace issues is critical to make sure that you actually satisfy your obligations to investigate.
Yeah.
And I think one of the important steps, of course, is the investigation itself and who's conducting the investigation.
Mm-hmm.
Of course, there are HR personnel that are qualified and are permitted to conduct the investigation, but oftentimes there are personal relationships involved. There's friendships or companionships, and maybe in the example that you provided, that wouldn't be a situation where we would recommend that the company conduct the investigation themselves. There may be a friendship, and that could jeopardize the integrity of the investigation. And so thinking about outsourcing this to a professional third-party investigator so that they can ensure that there's the investigation is completely neutral. They take all the appropriate steps. Of course, they're either an attorney themselves or certified by the state of California. Just really to ensure that there's a clear track record of the investigation, of the proper steps of the investigation, and obviously an outcome and conclusion, and correct disciplinary measures where necessary.
And to dovetail off that, I do agree that it's important to make sure you have a qualified investigator who's going to be impartial, right? Because that investigation, if there's ever any litigation, is going to be the subject of a lot of that lawsuit and discovery, right? And so having someone who knows investigation techniques and understands it, is really important, because California does have a lot of materials and resources about how to conduct an investigation and appropriate scopes of investigation. Sometimes they are available on the Civil Rights Department's website, but they do have that. And so if you do have an employee who later files a lawsuit about this investigation because they never received any remedial response to it, or they don't feel like they were apprised or anything like that, they're going to look. The Plaintiffs' Counsel will look to those resources and say, hey, did you ever review this? Did you know this? And if you don't have somebody who's a well-qualified investigator who has any training on investigations, you might have some problems there. But I also agree too with Olga earlier. It's really important that supervisors know to report those complaints, because that's what we frequently see, is that a supervisor hasn't, or another employee has not reported it, and it was something that everyone kind of knew about, but no one ever mentioned it to HR, and HR never got wind of it. So and then we had the lawsuit, and all of a sudden it is an actual issue that needed to be addressed at that time, and no one did. So.
Yeah. Well, what I've been seeing a lot of lately, employees who make these complaints on their way out, right? On the day that the employee is terminated for poor performance or violation of company policy, on their way out of the exit interview, say, by the way, I was sexually harassed. And you're going, okay, now what? Yeah. Right? Is the employee, are we relieved of our obligation to investigate just because the employee is gone? I mean, collective shake of the head, right? No, absolutely not.
Wait, we took remedial action. They're gone.
And that would be a lesson in making sure you never punish them, allegedly.
Right.
No, and it's tough too, because then chances are you're also going to get an alleged victim who is uncooperative and may not even agree to participate in an interview, right? You have to make diligent efforts to make sure that you actually try very hard to interview them, and then at a certain point you have to make the call to just proceed and conduct the investigation without their input. Right. But you have to do the investigation.
Yeah. No, you do have to do the investigation. If you do have somebody who's raising on their way out, you need to make sure that you're doing a good analysis too of your termination decision, because while you might have legitimate reasons to, the timing of it's going to really look suspect, and it's going to make it very difficult in a defense of the action to maybe necessarily get it dismissed, before shorter trial. So I think it's always really important to kind of consider all those factors and make sure you have good documentation throughout the performance issues, because they always conveniently complain and we have performance issues and then we terminate them, and not a lot of documentation.
So it's kind of a trade-off, right? If you have the resources, getting an outside and a neutral, independent investigator is useful. That's not always feasible. So HR people are certainly qualified, but you have to be mindful that there's a cottage industry out there in the plaintiff's bar of HR experts that attack every step of the investigation. It's impossible to do a perfect investigation, even for the government to do a perfect investigation. So you just have to be mindful of that when selecting an investigator and communicating internally about the decisions. That everything that's written down could be Exhibit A blown up in front of a jury. So it's real important to get qualified investigators, whether they're internal or outside. Anything to add? I think we're almost to the witching hour, too late to start a brand new topic. Although I feel like we covered a lot of them in the process, like protecting data, and any other questions that people have, feel free to email us. I promised at the outset, we will make sure every question is answered. Even if we don't yet know the answer, we'll look it up and research it and give you an answer. I have a little script here for my closing. Thank you, everyone, for joining us today. And we hope the information that we provided was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. Certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. How delightful. The last point here is be sure to complete our short survey, very short survey. We all love doing surveys. Your feedback is really important to us as we plan for the next program. It could be a webinar in January. It doesn't have to be annual review. We like doing timely, interesting webinars as well. So this concludes our webinar today. Thank you, everybody, for attending virtually. And for those thousands in the audience who attended live, thank you so much for being here. We really appreciate your attendance.